I'm not.
Okay.
Oh, sorry.
Remain seated, come to order.
Okay, go back. All your evidence being stated.
Yes, Judge.
Right there, please.
Okay, Judge. Good evening. I'm here to speak on behalf of my family. Throughout this entire trial, the defense has tried painting a pretty picture for you all, so I would like to do the same. It's July 18th and it's a celebration. My niece, Layla Marie Daniel, is turning 6 years old today. While she's outside playing with her sisters and her friends she made this year in kindergarten, we are prepping her birthday cake with 6 candles. She's surrounded by gifts and decorations, but most importantly, she's surrounded by love. I picture the happy, smiling, and healthy little girl so many people knew her to be, and it breaks my heart, bringing tears to my eyes every time I think of how she would look now and how happy she would be. The truth of it all, exactly 2 weeks ago today, it was July 18th, 2019, and instead of attending Layla's 6th birthday, I was here with you all listening to the brutal details that her and her sister went through while living with the Rosenbaums. We've had to sit through and witness photos of an innocent 2-year-old speaking in a broken little body and listen to the horror that ended up in her murder impacting my family. To Millie and Layla, I was, and I still am, their Aunt Kat. And during this trial, our side of the family's efforts and suffering throughout this process have gone untold. We love Layla, and we would have done anything for her. Before my nieces were placed in any homes, I took Layla everywhere with me. She looked just like her Aunt Kat, so much that everyone in the family would call her my mini-me. She was more than my niece, she was my baby. And I was excited for her to experience life, to learn, to grow, and to hopefully see her continue to look like me for the rest of her life. We went through the proper steps. We had our home set up. We took the drug test. My brother was working through his case plan. It was Jennifer that didn't do the proper steps and lied. DFACS put a stop to all of my wishes for Layla, overlooking our efforts, and instead placed Layla in a home that would be her last. While the defense tried to paint this pretty picture for you of the loving Rosenbaums with their 2 foster children, they also tried to focus on the mother's side of the family's flaws to try and make you believe that nobody in these girls' lives loved them like the Rosenbaums. But as we witnessed, that is not the case. We all love those girls more than they ever did or could. We heard a witness testify that grief comes in stages, and it usually takes 48 hours or 2 sleep cycles to get a full grasp on the trauma someone has experienced. Since I lost Layla, I've had nearly 4 years of sleep cycles. And my thoughts on the outcome of this trial have changed throughout these years. I respectfully ask that they both be sentenced to life in prison without parole, bringing them plenty of sleep cycles to come to terms with what they've done. To think of the pain they inflicted upon these girls and to count up the days that they were so selfishly and hatefully took away from my Layla. Thank you, Your Honor, for giving me this time
All right,
to
and
represent my family.
please state your true and correct name.
My name is Caitlin Daniel.
All right, thank you, ma'am.
Thank you for the opportunity today to be the voice for my girls, Layla's sisters. 4 years ago, almost to the day, Millie and Layla moved into the Rosenbaum house. The girls were told they would be safe, they could trust them, and even that this was a good thing. However, 3.5 very long months later, we found out the truth. During their time living a life of hell on earth, these babies didn't feel like they had a voice. Even now, almost 4 years later, Millie is being made out to be a liar when in fact, Jennifer's the one who taught her to lie in the first place. Thankfully, we have all heard the evidence which supports Millie's statements back then and still today. Jennifer is the one who has been proven without a doubt to be the real liar. While Jennifer and Joseph have been free to live their lives for the past 4 years, Millie has been learning to live a life without her sister and learning to trust and feel safe again. Layla's younger sisters will live the rest of their life mourning a relationship they will never get to have. They will only know their big sister Layla through 2 short years worth of pictures and stories they will only hear secondhand. I teach my girls each and every day about choices and consequences. Jennifer and Joseph make horrible choices that will forever affect the lives of so many, but most of all Layla and Millie. Most of the adults in Millie and Layla's lives failed them repeatedly. It's time to show Millie her voice was heard and it matters. We need to show Millie and everyone else that what happened in that house is not okay. I want Millie to feel safe riding her bike in the front yard again. I want Millie to be able to trust her judgment in good and bad people again. I want Millie to believe in and trust the justice system when she is older. Now is the time, albeit long overdue, for Jennifer and Joseph to face the consequences of their actions or lack thereof in Joseph's case. I respectfully ask that you sentence both Jennifer and Joseph Rosenbaum to the maximum time allowed for each and every count they have been convicted of.
And ma'am, would you please state your full name?
Amanda Harrell.
All right, thank you, and we appreciate you being here.
My name is Kimberly Fry, and I am Millie and Layla's great aunt. And I'm going to read my mother-in-law's impact statement for her, Peggy Banks. How has your heinous act affected my family? Well, let me count the ways. First and foremost is the obvious, the loss of my precious great-granddaughter, Layla Marie, which has left a sizable hole in our family and in our hearts. Layla will never experience her first day of school or look forward to summer vacations from school. She will never celebrate high school or college graduation, never have the excitement of her first date or looking forward to planning her wedding. Layla will never experience motherhood and certainly never give me any great-grandchildren, excuse me. All because of their selfish need to inflict the ultimate harm on a 2-year-old baby girl. Layla's death obviously had the most impact on her parents, but also affected her grandparents, great-grandparents as well, and not to mention aunts, uncles, cousins, including my children and siblings. I'm most concerned about Millie, as she was most directly impacted, and in a negative way. This child has been in counseling and therapy ever since this happened. Her life will certainly never be the same. I fear the complete effect on Millie may be felt for years to come, possibly lasting the rest of her life. Now Layla has 2 more little sisters who will never know or be able to love her as we did, never be able to play with her, look up to her, or call her their big sister. Your actions also negatively affected the Department of Family and Children's Services and the foster care system program, setting it back decades. The entire community has been upset over this murder. In fact, the family frequently heard from people in other states, some who traveled here to offer consolation and support. Finally, your own lives are forever ruined as a result of their hatred and abuse of these sweet little girls who never hurt anyone in their short lives. And I hope they have a long, long time to think about their actions and all the lives that have been affected by them. Peggy Banks.
Thank you, ma'am. We appreciate you being here.
My name is Kim Smith, and I am Layla's great-great-aunt. That may sound like a very distant relative, but believe me, it was not. I wasn't there when Layla was born, but within a year she became a very bright, bubbly, sweet addition to my life. I am the last relative, besides Millie, that saw her and held her for the last time that she was alive. That day will haunt me forever. I saw something in her eyes that wasn't quite right, but I didn't act because I didn't know. Just the fact that the girls were in foster care impacted our family. It was dysfunctional at best. The girls were moved from pillar to post over and over. So when the Rosenbaums were to get the girls, We really did think that it would be a stable situation until our family could get them back. Fast forward to November 17th, 2015, the death of Layla and the trauma for Millie. Then the details began to surface. We mourned Layla and we mourned with Millie. The media attention, we didn't ask for that. It was pushed upon us. Our family didn't want a civil case with defects. We wanted our Layla back. Lawyers, district attorneys, judges, all coming and going and changing. The case being scheduled and delayed again and again. This has been weighing heavy on our hearts for 4.5 years. From now on, we'll refer to our life before Layla died or after Layla died. We've had many people pray for our family, some from all over the world. Most all people you meet are disgraced by anyone that would harm an innocent child, much less beat a child until her internal organs tear and bleed and her bones break. To traumatize a child while she witnesses this happening to her sister, knowing it would happen to her as well. Jennifer and Joseph, you not only killed Layla and traumatized Millie for the rest of her life, you also broke the hearts of everyone that knew her and the hearts of your family as well. In my deepest time of grief and despair, I pleaded with God to let me just see Layla again. I didn't want to remember her lifeless, unrecognizable body in that baby coffin. That could not be my last memory of her. That night, Jesus gave me the sweetest dream of Layla in heaven. Layla's body is perfect now, just the way God created her to be. Oh, her hair is healthy again, not straw-like and falling out. It is shiny and longer now, like Millie's. And when she runs in the meadows of wildflower, it bounces. There is yummy food there, and she can eat it whenever she wants. There are ponies and puppies there, and kittens too. And Jesus always has time to play with her. There is so much love and happiness. There is no room for anger or bitterness. Everyone there is like family. But she really does have family there. Lots and lots of family. And she can't wait till the rest of us get there. Layla is in heaven, waiting for all of us. Thank you to everyone that prayed for my family. Jesus heard every prayer, and he comforted and loved on and provided peace to all that simply asked. Jennifer and Joseph, forgiveness has taken the place of hate and bitterness in my heart. However, we all must pay the consequences of sins, and according to the laws of this land, punishment of murder must be met. You have been found guilty, and I pray that you are punished to the full extent of the law. I also pray for your souls. To this day, I have not seen 1 ounce of remorse, 1 ounce of acknowledgement to the horror that you put these girls through. Yes, God will have the final judgment, and may he have mercy on your souls. Thank you, Judge.
Thank you, ma'am. And thank you for being here.
Thank you.
All right. Does that conclude the state's evidence? One more?
Yes.
Okay.
My name is Daniel, and I'm Layla's mom. And I just wanted to say that they were given an opportunity to have a really precious baby in their life. And instead they took her life. And I've blamed myself over the last 4 years a lot for what's happened to my baby because of my actions that caused her to be in their home. But I just want to say that now I see that I don't have to blame myself anymore because I never hurt my babies. I love them very much. And I just hope that the time that they do in there
that they really have time to feel something. I hope that they can feel something. And
Thank you, ma'am. Thank you for being here. All right. Is there any additional evidence from the state?
No, Your Honor.
Ms. Small, any evidence from the defense?
Yes, Your Honor. Timothy, Mrs. Michael Rosenbaum coming up first. Where would you like him to stand?
Just right here would be fine.
Your Honor, my name is Michael Rosenbaum. I'm Joseph's father. I don't have a piece of paper I'm not reading from you, so I'm not prepared for this statement, but please be lenient. I know this all could have been prevented if the biological mother and the family, it started, when that child was born, it starts with them. That's the first step of responsibility. This all could have been prevented if they would have took that responsibility and not diminished themselves with drugs and alcohol. That's a sad thing. Alcohol and drugs are bad. But just please, minimum sentence, if whatever minimum, and he has CF and diabetes. Just please have the state take care of him and suicide watch. I know he wanted to take his life. That's why.
Thank you for being here. Thank you for your statement.
My name is Mike Jackson. I've had the honor of knowing her for the last 6 months. She's worked with me. And I've heard all this stuff, but knowing her like I've known her for 6 months, most Christian lady I've ever met in my life. I've seen her stay after work and make gifts for the kids at her church. And I go to my grave thinking she did not kill that child. The child died. But I think it died with her trying to save it. That's all I can say.
All right. Is there any other evidence from the
Yes,
defense?
Your Honor.
come up here.
My name is Casey Galentine. I don't know the Jennifer that has been portrayed in this courtroom. I know a smart, plenty kind, generous, and faithful person. I respect our justice system and I respect this process, but I fear this time they got it wrong. I've had many people question my loyalty to Jennifer during this ordeal. But the things said in this courtroom and the accusations that were made are completely inconsistent with the person that I know. She's been through more in her short lifetime than most people ever have, and she thrived. Jennifer and Joseph were broken by the death of Layla, completely broken. They loved those girls with their whole hearts. The ripple effect of this accident is so far-reaching, as evidenced by all of the people here today. But I do believe that's what it was, a tragic accident. They will never recover. No one in this room will. I respectfully ask you to have mercy on Jennifer and Joseph to the extent that you're able.
My name is Summer Wells. I was with those girls most of the summer that year. There was nothing wrong with them. They weren't hurt. My son knew them. He grew up with them. We went with them everywhere. My sister and my brother-in-law, like they were their own. And my son is going to be in pieces when he figures out he's never going to see her again, or whatever he would choose. I believe in the justice system, but they did get it wrong this time. And they didn't prove anything when they stood up there and did their whole thing and whatever else they did. But my son, he loves them with everything in them. And his 10-year-old self is going to be very upset when I go home to tell him that he's never going to see again. And every time I show him pictures of Layla and Millie, he talks about them too, and so I know that they got this wrong this time, and the death threats we've been receiving and everything we've been receiving from that side of the courtroom and their little group and everything like that, for them to sit up here and say the things that they've been saying about my family and Jennifer and Joseph is beyond me. So please.
Your Honor, I don't have a speech. I didn't know I was going to be coming up here, so I'm just going to speak from my heart. I'm Joseph's mom, and I've known Jen for 10 years, since 2009. Everything that I feel in my core, everything that I have ever seen, they were good parents, both of them. They would never do this. It was an accident. I don't care what anybody says. I'm gonna throw up. Please, be lenient on them. My son is going to die in prison because they're not going to take care of him. Like he said, the care that he's needed on the outside. So I've lost my son. And not just to prison, but I have actually lost my son. I am sure. So please be lenient. That's all I have.
All right.
Thank you.
Ms. Wolf, anything else? Thank you. Let's turn to argument. I think it's the right opening.
Yes, Judge. I will start with the matter of the indictment and what charges will be vacated as a matter of law and which ones will not. I would say that as counts 3, counts 5, and counts 7 would be vacated as a matter of law into count 6, the felony murder. That's pursuant to Anthony versus the State, 303, Georgia at 399. It's a 2018 case.
Vacated in count 6.
That's correct. Which is the felony murder. The court's sentencing options as far as the felony murder count, the only options the court has is life or life without the possibility of parole. As far as Mr. Rosenbaum, he was convicted of both counts 8 and counts 9. Count 9 would be vacated as a matter of law into count 8. The penalty range for murder in the second degree is 10 to 30 years. As far as the aggravated assault and cruelty to children, pursuant to Kurt versus the State, which is 309 Georgia Appeals 227, and I have a copy for both defense and for the court. Because aggravated assault and cruelty to children in the first degree have different elements that are not present in the other one, as a matter of law, they actually are not vacated, and the court can sentence both of them, sentence the defendants for both of them. So that would be, for example, counts 10 and 11. Pursuant to that case law, they actually would not merge as a matter of law. The same is kind of true throughout the entire indictment. Counts 12 and 13 are related, but pursuant to the case law, they do not merge. Counts 14 and 15 are related, but pursuant to the case law, they do not merge. They're not vacated as a matter of law. 16 and 17, 18 and 19. And if you need me to slow down, I can do that, Judge. But the cruelty and children, I guess.
So far you're telling me
Yes.
which counts are not vacated.
The aggravated assaults and the cruelty to children counts that I guess are related when you look at the dates. They do not merge as a matter of law. The court can sentence them separately. The same is true with cruelty to children and aggravated battery, because that similarly has an element specifically. Cruelty to children requires cruelty to children, but not aggravated battery, requires proof that the victim was a child under the age of 18 who was caused cruel or excessive mental pain. Aggravated battery, but not cruelty to children, requires proof that the victim was deprived of a member of his or her body, or in this case, as was indicted, such member was rendered useless or seriously disfigured. That is pursuant to Waits, W-A-I-T-S, versus the state. That's 282 Georgia 1. That's a 2007 case from our Supreme Court. So similarly, the aggravated battery counts and the cruelty to children counts that have the same date, as a matter of law, they actually are not vacated. The penalty range for aggravated assault, cruelty to children in the first degree, and aggravated battery, each of those carry a penalty range of 1 to 20 years for each of them. As far as the remaining charge that is different than the other ones I just discussed, that would be counts 48 and 49, cruelty to children in the second degree. The penalty range for cruelty to children in the second degree is 1 to 10 years. So the penalty ranges for murder, as I mentioned, there's life without parole. Murder in the second degree is 10 to 30. Aggravated assault for cruelty to children in the first degree and aggravated battery are all 1 to 20. And cruelty to children in the second degree is 1 to 10. Your Honor, as far as argument is concerned, a jury of the Rosenbaum's peers has spoken. This jury clearly deliberated long and hard and came to a very wise and just verdict given the facts that were elicited during the course of this trial. The state is asking, given the egregiousness of this crime, that the fact that this was a 2-year-old victim, that under no circumstances could have ever have done anything to either of these two individuals to provoke any of the treatment that they received while living in that home. The fact that there was prior abuse that was shown, and the jury has convicted them not only of the things that were committed on November 17th of 2015, but they were convicted of abuse that occurred prior to that day as well, which was borne by the evidence, specifically multiple fractures, healing fractures, and the evidence that Dr. Darasol was able to see under the microscope, and she testified here today. This was not a single incident. This was a pattern of abuse, and given the egregiousness of that, as far as Jennifer Rosenbaum is concerned, the state is seeking a sentence of life without the possibility of parole. Plus, she is also facing, if you total up the remainder of the charges, she is facing a total of life without the possibility of parole plus 780 years. The state is seeking life without the possibility of parole plus all counts to run consecutive. As far as Joseph Rosenbaum is concerned, if you add all of the charges up, Mr. Rosenbaum is facing a maximum possible penalty of 410 years in the Department of Corrections. The state is seeking a penalty for Mr. Rosenbaum of 70 years to serve 50 years in custody, the balance of which to be served on probation. We think that given the evidence that the court has heard during the 3-week trial, I think that these sentences are just given the egregiousness, the seriousness, and the vile things that we heard that occurred in that home. So for those reasons, Your Honor, we would ask the court to follow the state's recommendation.
Thank you.
Your Honor, I want to talk first about Joseph Rosenbaum. Joseph Rosenbaum suffers from cystic fibrosis and has diabetes. His life expectancy is less than half of what the state is asking for in this case. He is faulted with not taking action, which is an act of negligence, is what the jury found. And even if we accept, which we do, the verdict of the jury, they have found him to be negligent. They have found that he was a party to a crime as to the other counts. Your Honor, there was no evidence that Joseph knew or should have known, and that's not even the standard. The standard is that he knew. There was no evidence that he knew. But given the jury's finding, I know the court has to make a decision. I'm asking the court to consider a much, much less sentence, given the fact that this is for negligence, for a negligent act. He was working 2 jobs at the time. He was a correctional officer, and he was working security at Lowe's. He didn't have much time to be around the girls. What time he did, according to the evidence, he was good to them. That was the evidence that was brought out, that he was good to them, that he treated them well, and that he didn't do anything to them. I don't think that warrants 70 years. I think that warrants 5. Your Honor, I would ask you to consider, as I say, the shortness of his life, and that we are not all the sum total of what we do on one day or what we fail to do on one day. These both, Jennifer and Joseph, come to you with absolutely no record whatsoever. They come to you having had no brush with the law whatsoever. Jennifer, Your Honor, was a law student. She was a very good law student. She did a lot for a lot of people, and the girls no lesser than anybody else. As we have heard, the evidence is that she did love them, that she did give them the love and care that one would expect. We differ with the jury as to the cause of death, but we understand responsibility, and Jennifer understands responsibility and has always blamed herself. I'm asking that you consider a life sentence for her, and that you not. We have had many criminals come up with life sentences as opposed to life without parole. We reserve life without parole for the most egregious. Jennifer Rosenbaum is not the most egregious of people. She grew up in the foster care system. She was a child of defects for the longest, and she did what she could and what she knew to do best. I'm asking that you consider a life sentence for her. I'm asking the court that you consider the least amount of time you can give for Joseph in this case, and to stack counts against Jennifer defeats the purpose of rehabilitation. This is somebody who comes with no record. Both of these individuals have no record. They have been contributors to the community. You've heard that repeatedly, both during the trial and after the trial. These are not people who have sucked from the community, but instead have given to the community. Again, we are not the worst that we have been on one day. We're made up of more, and I'm asking for mercy for both of these young people and that you consider minimum sentences for them both. Thank you.
Thank you, Ms. Small. Any final quotes? Briefly, Judge.
As far as Mr. Rosenbaum is concerned, Ms. Mull is right in that murder in the second degree is based upon negligence. But that negligence cost Layla Daniel her life. That is the most negligent thing that a person could possibly do, knowing that abuse is going on in the home and doing absolutely nothing about it, leaving Layla in the care of the person who is abusing her. The evidence that he knew was Millie's statements. Millie mentioned that he knew that he would stand there and he would watch. We also heard from Ms. Lambert that Millie actually told her that Joseph had hit her. We know from Millie's statements that he would put icy hot on their wounds, and that he also did nothing regarding the fractures. Millie, when Millie went to the hospital on November 17th of 2015, that was the first time anyone had ever realized that she had a fracture as well, a fracture that would have been painful, a fracture that the doctors testified that any person around a child with that type of fracture would clearly know that it was going on. He did nothing. That negligence has cost Layla Daniel her life and has forever changed Millie's life. For that, I think the state's recommendation is more than reasonable as far as 70 years to serve 50 years in custody. As far as Mrs. Rosenbaum is concerned, Ms. Mull first said, one of the last things she said to this court was that we are not the worst of what happened on one day. I have to remind the court that this is not something that happened just on one day. This was a pattern of abuse that occurred over a relatively short period of time, but it was a pattern of abuse that was incredibly increasing. It was a pattern of abuse that ultimately cost a 2-year-old child her life. And to say that that is not the most egregious thing that this court would ever have to hear is astonishing to me. This has to be one of the most egregious things. When a 2-year-old child is punched or kicked or stomped with blunt force to her torso, severing her pancreas into two, lacerating her liver and her mesentery to the point where she bled out in less than an hour. The final moments of her life, as Dr. Darasaw testified, would have been her bleeding internally, going into shock, and ultimately dying in front of the person who killed her. Those were the last moments that she had on this earth. I can think of nothing more egregious than that. The state asked that the court follow the state's recommendation of life without parole, plus the remainder of the counts to run consecutive.
All right. I'm going to take just a few minutes to review the cases that Mr. Chase has submitted, ensure that they're correct, and I'm going to return with the sentence. During this 10-minute recess, I expect that decorum will be observed in the courtroom. There'll be no outbursts or crosstalk. As between people who are here in support of the defendants and people who are here in support of the state. If you cannot abide by those instructions, then you'll be immediately asked to leave. I hope everybody understands that. I'll be back in just a few moments. Thank you both for your argument.
Remain seated, come to order.
Okay. There'll be the order of judgment report. Ms. Jennifer Rosenbaum, would you please stand? There'll be the order of judgment report that count 3 be vacated and count 6. That count 5 be vacated and count 6. As to count 6, you'll be sentenced to a term of life in prison. As to count 7, it's vacated to count 6. As to counts 10 through 41, you'll be sentenced to a term of 20 years to serve. Those 20 years will be served concurrent with each other and consecutive to the sentence pronounced in count number 6. As to counts 42 through 47, you'll be sentenced to a term of 20 years. Those sentences will run concurrent with each other and consecutive to count number 10. As to count number 48 and 49, you're to receive 10-year prison sentences, and those are to run concurrent with each other and concurrent with the other sentences that the court has imposed. All told, this is a life sentence, plus 40 years to serve in the state penitentiary. You have 30 days from today's date to file a notice of appeal. You have 4 years from today's date to seek any habeas relief that you deem appropriate under the circumstances of this case. You may be seated. Mr. Joseph Rosenbaum, please stand. It will be the order and judgment of this court to be sentenced to a term of 30 years in the state penitentiary. As to count number 8, count 9 will be vacated in count number 8. As to counts 12, 13, 14, 15, 18, 19, 22, 23, 26, 27, 30, 31, 42, 43, 44, 45, 46, 47. You'll be sentenced to a term of 20 years to serve in the state penitentiary. Those sentences are to run concurrent with the sentence that's been pronounced in count number 8. As it relates to count 48, you'll be sentenced to a term of 10 years on probation to run consecutive to the sentences pronounced in counts 12 through 47. And as to count number 49, you'll be sentenced to a term of 10 years on probation to run consecutive to count number 48. All told, yours is a 50-year sentence with 30 years to serve in the state penitentiary. Sentence having been pronounced, you may have a seat. I should also say the same to you that I said to Mrs. Rosenbaum, that you will have 30 days from today's date to file a notice of appeal. You'll have 4 years from today's date to file for any habeas relief that you deem appropriate under the circumstances. There are a lot of counts here. Let me just double check with the state and with the defense that we have covered them appropriately in terms of completeness and in terms of calculation.
Yes, Judge. It appears that all the counts for which they have convicted, they were sentenced on.
All right, and the pronouncement as calculated appears to be correct.
And Judge, if I could just add one thing regarding the merger. One of the reasons why the counts merged into the felony murder is because that was the act that actually caused the death. The other actions in the indictment on November 17th were not the cause of death, they were simply other injuries that were on the child.
All right, and so I've correctly stated your position regarding what counts are to be vacated.
That's correct.
All right, and let me just also add, that it is deeply frustrating for the court to hear family members of the defendants quarrel with the verdict that was rendered in this case. This case was carefully tried. And I'm deeply concerned of the lack of recognition on behalf of the defendant's family of the scope of the tragedy and of the cause of the tragedy. I've lived with this case for a long time too. And I will tell you that it is one of the worst, most horrible crimes and outcomes that anyone could ever experience or dream of experiencing. And so I just want to say that I feel for and am deeply pained by your loss. And I hope that you will somehow find a way to recover. Sentence having been pronounced, is there anything further from the state?
Nothing from the state.
Is there anything further from the defense?
No, you consider an Alabama pending appeal.
I will not. Thank you. I will conclude this matter. Your turn.
Do you want these two cases?
Has nothing to do with it. Yeah.